Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recording live from FYP Studios East and West and more West, transmitting across the internet. This is episode 310 of Registry Matters. Larry, did you know you put 320 in there earlier?
I don't make those kind of mistakes.
I was like, it's not 320 yet. That's a couple months away. Anyway, how are you this evening, Larry?
Doing awesome. How are you?
I'm all right. I'm working a lot of hours, so to me, it feels like it was Monday about 2 hours ago.
Good for
but,
you.
You know, I suppose. Chance, how are you? Welcome back.
Well, thank you very much. I'm before you even ask, I'm doing much better. Great. Thank you.
Perfect. I mean, you must have a stellar tan from all the time you spent at the beach.
A stellar tan it is. That's correct.
Fantastic. I like it. Perfect. Please, if you'd be so kind, head over to your favorite podcast app, or if you're watching on YouTube, click that thumbs up thing. You can also press subscribe. And if the minimum that you could do is go leave a 5-star review, that would also be very helpful. We do have many reviews, and I think they're all, I haven't seen any negative ones. But anywho, go over there and do that, and it would be really fantastic to show some support and love and all that. Larry, what are we doing tonight?
Not very much.
Okay, good night.
So we have a case that deals with felon disenfranchisement. You go ahead and say it.
Felon disenfranchisement?
From the Fifth Circuit Court of Appeals. We have another case that deals with mail interference by a correctional facility that's in Illinois. And for our incarcerated audience, they're going to find that one to be of interest. And we have Chance back this week with a California coroner about positioning yourself for, what are we positioning yourself for at the California coroner?
Reintegration, which is post-conviction relief in its essence.
And we have articles, but time's not going to permit, but we will get to at least one article because it is similar to the felon disenfranchisement that we're going to be talking about. So it parallels that from Nebraska. So, and we have a YouTube comment, and we have a question from patron John.
Perfect. Well, let's head over to the YouTube comment right off the bat. It says, when you're pulled over, this is referencing what we talked about last week, where a person was asking about how do you sell a car? How do you deal with the person that's on the registry that happens to be behind bars and sell your car to them? But anyway, so when you're pulled over, you hand the officer your registration, which has your VIN number right there. No flashlight required. But you're right. The license plate number is all they care about.
Well, I appreciate both those points. The license plate number is all they care about. But the VIN number is on your registration, assuming that you hand it to the officer. But the point I was trying to make was that when the officer comes up at that particular moment, they have already, in their standard operating procedure protocols, they've already radioed in your license plate number, or they've run it with their vehicle that's in their computer they have in their vehicle. They've already run that license plate number. It gives them an early warning system about who they're dealing with. So that was the way I was trying to tie it together, that when the officer comes up, if that is a PFR car, in terms of it's in the database associated with PFR, they likely already have that information. And in my experience with dealing with officers and asking them protocols, asking them relentless questions when we have downtime in the Capitol, I've asked them about how often do they run VIN numbers, and they tell me that as a general rule, they don't run VIN numbers unless there is some disconnect between the paperwork and the driver, and there's something that would inspire them to have a need to run the VIN number. So that was the snarky comment I was making, is to run the VIN number, they would have to take your registration and either go get on the radio, or they would have to punch it in or call it in. And if you don't have a registration, then they would need to get the VIN number somehow. But the issue is really still simple as far as I'm concerned. If you need to sell the car and you have authorization to sell the car with power of attorney and all the things that this listener said that she has, you just sell the car. And if the license plate number is on the car, is registered to a PFR, and you happen to be in that small number of states where the plate goes with the car and not with the vehicle, all you would do is not give that plate to the new owner. You would tell them it got damaged. You'd tell them it got stolen. Or you would do any number of things to make sure that a new plate's going to be issued to the new owner. And then that would eliminate that connection to the PFR, in my opinion. Now, Chance, you're here, and I think that my state research, California was listed in the handful of states that still uses plate to owner. I mean, plate to vehicle versus plate to owner. But if California does do the plate to vehicle and it goes to the new owner, the same plate, I mean, is there anything wrong with not giving that plate? That's just, you'd have to purchase a new license plate from the motor vehicles, but they have to have a process. This wouldn't be the first time a car has ever changed hands when the plate didn't exist, but that doesn't mean that the car could not have a license plate. I mean, that's ridiculous. Well, what am I missing here?
Yeah. Well, no, I'm not sure how California operates now. I mean, we have personalized plates, so it might be plate to owner, but during the transfer, you sign off, the other person signs on. It's as simple as that in California.
It's pretty simple to sell the car. The only question is whether this person has the authority to sell the car, and it sounds like she does. So sell the car if that's your desire. Let the new owner register it. They won't have any problem. And if they did have problems, this would be what I would suggest doing if there were to be any problems. This would be ripe for a judicial pleading, and you would file a mandamus because the agency is required to issue license plate registration stuff to people who are qualified. So if you've got a bona fide buyer that bought the car and there's nothing that precludes them from registering a car, then that administrative agency would be failing to do its job, and that would be ripe for a mandamus proceeding.
Okay.
Anything else, Chance?
No, I think that's good.
So
that covers it.
That's what I would do, but I don't think it's going to ever come to that. I just think it was an overreaction to call the sex offender registration office to ask that question, because they don't deal with registration of vehicles. They deal with registration of offenders.
Yeah, wrong instrument.
So.
Well, let's move over to this question. This is from a pretty new patron, and he was also kind enough and probably more borderline like crazy enough to up his support for the program. And that's very much appreciated. And he says, I live in Rhode Island, and I am not serving prison time because I accepted a plea deal that includes 15 years of probation. As part of the plea bargain, I also have to comply with SORNA for more than 15 years while on parole. I asked my lawyer about whether this plea agreement is binding. 3 of them said that we could go back to court, but the case would be reopened. Can you recommend anyone who might be able to help me? I think there might be a little bit of confusion even in the way the question is asked of how these things all relate together.
There's definitely some confusion. So, John, you may want to clarify it for the next episode. But the 15 years probation, the only thing I can see he might be angling about is he has 15 more years to do on the registry. If they start the registration clock when you exit probation, that may be what he's asking about, but it's not totally clear what he's trying to do. But the plea agreement they don't impose registration in most plea agreements. They admonish you, or apprise you, I should say, not really admonish, but they apprise you of the duty to register. Because under Padilla versus Kentucky, the Supreme Court said decades ago that a person has to be apprised of the known collateral consequences of their plea, because there can be severe consequences up to and including deportation. So therefore, it's important that you be informed of the consequences, but it's not something that's a part of your sentence. It's a collateral consequence, like the forfeiture of your firearms and voting rights and so forth. It's not a part of your actual punishment. You're not being sentenced to registration.
What about the part about the plea agreement being binding? I mean, like anybody that took a plea, we signed on the dotted line, and that's a binding contract.
Well, in my opinion and in my state, it's certainly binding on all parties. And we touched on that last episode when the person asked about if a modified judgment that did not include everything that was in the plea agreement, which was favorable to him, he would have had more time to do. Remember that one? He would have had more supervision, and they didn't put it in there. But that was in the plea agreement. So my answer last week was that both parties get to rely on the plea agreement. It's not just binding on one party. So if the state bargained for something, this is binding unless it's unconstitutional or unlawful. Now, but registration, as far as I know, in Rhode Island hasn't been declared unconstitutional. So, but I'm not really clear on what he's asking here. Chance, do you see anything in the question that makes it clear enough to you?
No, actually, I see a little bit of confusion here. I mean, he accepts a plea deal that includes 15 years of probation, but as part of the bargain, he does 15 more years on parole. But if you do probation, you don't go to prison. If you do parole, you're released from prison. So right away, I have a little bit of confusion about what this whole deal is about. So yeah, it's confusing. He's going to have to whittle it down some and be a little bit more accurate in his description of what this actually is.
In the first sentence, he says probation, and then in the second sentence, he says parole. Yes. Interesting, because parole would come before probation.
Well, it would come after prison. He'd have to go to prison first.
Right, I'm with you.
Yeah, I mean, in California, you don't get probation if you go to prison unless it's a federal conviction. So it's really hard to figure out what he's actually talking about. Federal versus state case, probation versus parole. There's a lot of moving parts here.
So, and just to complicate that, Georgia does split sentences, so you can go to prison, you can be released before your time, and then you're on parole, and then you move to probation.
So
okay,
right.
We will, John. Please feel free to engage again and ask a more pointed question. But there are some discrepancies in the way that you provided that question. I just threw it in here. I just happened to see the comment there he asked in Patreon, and so I figured I'd throw it in there. All right, well, moving along then. Oh, great. Well, Larry, you put this case in here from the Fifth Circuit Court of Appeals from the state of Mississippi. It deals with restoration of voting rights. I'm hoping that you will finally admit that federal judges appointed by one party are different from those appointed by the other party. Do you think that you can finally do that this episode?
No, I don't think I can.
Stubborn as usual. Let me set this up just a tad. Mississippi has one of the strictest bans in the United States. Now, let me read their law. This is me reading from their text, not lawyer Andy. Just want to make that clear. And it's actually in their Constitution. And it says, every inhabitant of this state except idiots, and does it say that?
It does.
Okay, now that's funny, Larry.
Wow.
Every inhabitant of this state, except for idiots and insane persons, who is a citizen of the United States of America, 18 years old and upward, who has been a resident of this state for 1 year, and for 1 year in the country in which he offers to vote, and for 6 months in the election precinct or in the incorporated city or town for which he offers to vote, and who is duly registered as provided in this article, and who has never been convicted of murder, rape, robbery, theft, arson, obtaining money or goods under false pretense, hold on, the list goes on, perjury, forgery, embezzlement, or bigamy, is declared to be a qualified elector, except that he shall be qualified to vote for president and vice president of the United States, if he meets the requirements established by Congress, therefore, and is otherwise a qualified elector.
Whoa.
So I think the idiots and insane persons, those are terms that were like readily used back in your youth, Larry, back in the 1800s when you were coming up. I think that was kind of like regular language.
Yes, this language dates back to their constitution, I think of 1890, somewhere in the
Oh my God.
1890s. And I was getting up in my adulthood by then, but
All right, well, this is some really broad and archaic language, to say the least. Idiots and insane persons are those convicted of PFR-type offenses are excluded. So what is your take on this outcome?
so just to clarify, one of the things you read, that you said country and you meant county, and 1 year the county. But okay, it means that the state of Mississippi can continue denying people previously convicted of certain felonies the right to vote because of a new ruling from the Fifth Circuit Court of Appeals. On Thursday, the court's majority overturned a ruling issued by a lower court and the Fifth Circuit itself, a 3-judge panel, which held Mississippi's disenfranchisement law was unconstitutional because it inflicted, quote, cruel and unusual punishment. The Fifth Circuit Court of Appeals found that the disenfranchisement is not punishment imposed on people for life, but a regulatory function of the state to protect the public and a function that is entirely within its right to flex. The majority also said that disenfranchisement isn't up to snuff when it interprets the cruel and unusual punishment, noting that acts such as hanging, burning at the stake, and beheading, to name a few. Now, those are not unconstitutional or cruel and unusual. I remember I've often pontificated in stating that if capital punishment isn't cruel and unusual, it's difficult to imagine that anything else can be. And this is why I say that, because this is not cruel and unusual punishment. If you can do all those things, then it's not cruel and unusual. Telling a person that they'll have to sit out an election doesn't seem to be quite to the level of beheading, does it?
It seems to be less than beheading, yes.
Okay.
All right, well, this case was filed in 2018 by 6 Mississippi citizens who have been permanently disenfranchised. Among them, Dennis Hopkins, disenfranchised since 1998, was convicted of grand larceny. Herman Parker Jr., a public employee of the Vicksburg Housing Authority, is disenfranchised because of a grand larceny conviction when he was 19. Byron DeMond Coleman became disenfranchised in 97 because of a conviction for receiving stolen property. These plaintiffs have completed all terms of their sentences. They sued the Mississippi Secretary of State in his official capacity, challenging Sections 241 and 253 and requesting declaratory and injunctive relief for alleged violations of the First, 8th, and 14th Amendments to the United States Constitution. What specifically did they allege, Larry?
Well, they asserted that the Mississippi Constitution, Section 241, inflicts cruel and unusual punishment of permanent disenfranchisement while it violates the Equal Protection Clause by impermissibly burdening their right to vote.
Section 1 of the 14th Amendment guarantees due process and equal protection of the laws. U.S. Constitutional Amendment, I guess that's 14, IV, Section 1. After a long process of, exegesis, it is settled that the Due Process Clause incorporates much of the Bill of Rights, and state governments must respect protections like the 8th Amendment's prohibition of cruel and unusual punishment. Section 2 of the 14th Amendment is less familiar but more specific. It reduces the number of representatives in Congress to which a state is entitled if that state disenfranchises any of its male, non-Indian citizens over the age of 21. But there is a single exception. States may not be penalized for disenfranchising a citizen for participation in rebellion or other crime. Has the Supreme Court previously affirmed lifetime bans?
Yes. The opinion references that in 1898, that seems a long time ago, the Supreme Court described felon disenfranchisement laws as a type of measure designed to protect the public and not punish for past offenses.
The dissenting opinion on the case comes from 6 liberal, pointy-headed judges, written by Judge James L. Dennis. They stated a lifetime voting ban is unconstitutional. Voting is the lifeblood of our democracy, and the deprivation of the right to vote saps citizens of the ability to have a say in how and by whom they are governed. Dennis wrote, permanent denial of the franchise, then, is an exceptionally severe penalty, constituting nothing short of the denial of the democratic core of American citizenship. Denying released offenders the right to vote takes away their full dignity as citizens, separates them from the rest of their community, and reduces them to other status. I respectfully dissent. And what do you say about that then, sir?
Oh, I agree with the dissent, but I also see the majority's logic. Judge Edith Jones wrote, "Go and convince state legislators. Do the hard work of persuading your fellow citizens that the law should be changed."
The original lawsuit was filed by the Southern Poverty Law Center, Simpson Thatcher, and Bartlett LLP, and others on behalf of state citizens who lost their voting rights. The Office of Attorney General Lynn Fitch opposed the lawsuit representing the state. What happens next?
Well, the court's majority stated it very succinctly. They said, if Mississippians want to remove disenfranchisement from the law, they will have to petition the Mississippi legislature to do so. Individuals can also ask lawmakers to file legislation to return their voting rights, but it must be approved by both the Senate and House and approved by the governor. Now, we don't want judges to legislate from the bench, do we, Andy?
At times, I think we do, Larry. When it is beneficial to what we want, yes, then I think so.
Well, now, wait, I'm getting lost here now. I have heard for my entire 200 plus years of adult life that we want judges who only interpret the law. They're not only interpreting Mississippi's law, they're interpreting Mississippi's Constitution and all that archaic language that's included in there, idiots and insane persons and whatever all you just read. Now, you don't want a federal judge that's appointed for life to come in and tell the good, hard-working people down in Mississippi that they can't write their own constitution and have their own. That seems like quite a stretch from not legislating from bench. That would seem just the opposite. That would be legislating from the bench completely to come in and undo that without going through the people of Mississippi.
I think, though, unless it's something we can't pass, suppose it's something that just will not pass through the legislature.
Well,
so then in a joint statement from several civil and voting rights advocacy groups, including the League of Women Voters for Mississippi, Mississippi Center for Justice, One Voice, Mississippi Votes, Mississippi State Conference for the NAACP, Black Voters Matter, and Mississippi Poor People's Campaign, they call the court's majority opinion a failure to democracy. Retaining this ban as part of Mississippi's constitution is an affront to our democracy, the statement reads. We are disappointed to see the court allow the state to continue taking the right to vote away from Mississippians for life under a state constitutional provision that was specifically designed to disenfranchise black men and that, to this day, disproportionately impacts black Mississippians. Larry, then didn't Florida reverse, it was their Fourth Amendment to their constitutional that banned felons from voting. So this is the same thing, essentially. And they got their constitution overturned, and the legislature came right back around, and I'll say it politely, they effed up their chances to vote.
They did, and that was initiated by the conservative lawmakers in Florida. But elections have consequences. We are allowed in a democratic society where we choose our destiny to impose bad laws on ourselves, as long as they don't break the Constitution. And the Constitution, under the conservative view, is interpreted very narrowly, that the states get to do this. This was a 13-6 decision when it was a panel of 3. I think it was a 2-1 panel decision, but then they filed for en banc, which is a full court review. And you can see that 13-6 is pretty lopsided. So that means there's a lot of people on the Fifth Circuit that don't believe there should be legislating from the bench, that this is a Mississippi decision. They don't see a constitutional infraction here, that not being able to vote for your rest of life is a constitutional right. So if you don't like that big an interpretation, then you've got to have different people appointed to federal judgeships and appellate courts. And what was appointed in the 4 previous years to this present term didn't help the courts of appeals at all in terms of broadening the interpretation. and what's going to be appointed after 2024, when we roll into 2025, depending on the outcome of the election, we're going to get more of these type of judges. So elections have consequences.
And Chance, I'm going to throw you on the spot. Which states does the Fifth Circuit cover? Obviously, Mississippi.
No, I can't remember what all states are covered there, but I could tell you one thing that, from my point of view, this is a constitutional hemorrhage. And, I'm not so sure the legislature, at any time is going to be able to fully fix it. And, this kind of race-based disenfranchisement is just, it is a tragedy. And it just bothers me. So that statement, that joint statement, is very compelling, and I would tend to agree with it.
So it's going to be Mississippi, probably Louisiana,
Texas.
What's above that?
Texas is in it, the Fifth Circuit.
Oh, okay.
Yeah, let's just call it the South.
Yeah,
right. The central South-ish.
Yeah, it was. It would have also included Georgia at one time before they created the 11th Circuit. Yeah, Georgia was in the Fifth Circuit at one time.
Does that mean Florida was then too?
I do believe it was.
Okay. That would make sense.
They created the 11th Circuit when Jimmy Carter was president.
Oh, look at you, Mr. Historian.
So,
but politically, how do you make this happen? I don't know if Mississippi has a ballot initiative the way that Florida did, where they put it on there and the people voted to revoke, to let the people vote again. Could Mississippi do the similar thing?
Possibly, but there are people in Mississippi who don't want that to happen. See, Mississippi already has, I think, the highest percentage of black voters in the country. I think the population is about roughly 40% black. And that it puts you in jeopardy of having black rule in that state if all the black people are eligible to vote. So there's this paranoia that blacks vote in lockstep with the Democrat Party. Now, that's not a true thing. Trump is going to prove that in this election cycle that that's not the case. But that's what a lot of people fear, is that would lead to radical control of the state government of Mississippi. And they point their hand, they will raise their, they'll say, look what's going on in Jackson. Do you want the whole state? Because Jackson is a hugely majority black city, and Jackson has its share of urban problems. And they say this is what you get with those kind of people running it, and it's a scare tactic. So it's not likely that the political process is going to be able to fix this. But if the judiciary was slightly more sympathetic to it, and if the case was built to show that it was racially motivated, you've got to prove that. You can't just do that with innuendo. You've got to come in and show, and I don't know how you would do that, but you've got to show that this was clearly intended to keep tens of thousands of blacks from voting.
Probably millions.
Well, I'm talking about in Mississippi, it's not millions, but in Mississippi, there's more blacks disenfranchised than any other ethnic group.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
Well, then, moving along to follow up on a similar situation that happened over in Nebraska. This AP story states that thousands of Nebraskans with felony convictions could be denied the right to vote under an opinion from the state attorney general released Wednesday that says a law passed earlier this year restoring the voting rights of people convicted of felonies violates the Nebraska Constitution. What is this about?
Well, this is Nebraska Attorney General Mike Hilgers, who said in an opinion that the law immediately restore the voting rights of people who finish serving their felony convictions violates the state constitution, separation of powers. Hilgers says that only the State Board of Pardons can restore the voting rights of people with felony convictions through a pardon.
The story states that pardons are exceedingly rare to come by in Nebraska, which requires those convicted of felonies to wait 10 years after their term to even file an application for a pardon. Hilgers' opinion was issued 2 days before the new voting rights restoration law was set to take effect. The American Civil Liberties Union of Nebraska said the opinion and efforts to block those with felony convictions from registering to vote could keep only 7,000, because, only 8,000 people live there, but 7,000 Nebraskan residents from voting in November.
Yeah, well, the ACLU is nothing but a bunch of leftist communist agitators, and they want to destroy this country. And can you not admit that?
Clearly, that's in their mission statement. You got to go hit on the about page, and then there's a little tiny dot that you have to click on their page that will open up the real agenda, right?
That's right. And
Okay.
What's humorous to me is very few PFRs support the ACLU, but it's the first organization that they call out for not doing enough on the PFR issue. And I'm saying, well, wait a minute. They run a business. They have to have revenue. They survive on membership dues, legal winnings from being prevailing party in cases, and you don't support them, but yet you resoundingly criticize them and you say that they're out to destroy the country and all this stuff. Well, if PFRs made up a significant amount of the ACLU membership, and when they send out their little surveys asking what their priorities should be, you'd be able to list PFR stuff in there. But PFRs don't join the ACLU because they're a bunch of liberal leftist communists.
There was the ACLU attorney there. I don't remember I don't remember if she was from Atlanta at the conference. Where was she from? She was from Atlanta?
No, she was not from Atlanta. You talking about Kim Budden?
Yes. So between one of the sessions or whatever, I ran into her and I asked her, I was like, so I'm just curious. I have heard basically what you just described is that you only have so much time and attorneys and all that stuff. And she's like, we've got people that can't vote. We've got all kinds of other civil liberty violations going on by large swaths of the population. And while maybe they would be interested in taking up PFR issues, they just have these other things that are more pressing and certainly, as you just said, of more interest to the donors.
Correct.
Anyway, I'm just saying that to confirm basically what you just said. So moving along, AG Hilgers also found unconstitutional a 2005 law that restored the voting rights of people with felony convictions 2 years after they finished all of the terms of their sentences. The opinion was sought by Republican Nebraska Secretary of State Bob Evnen. Hilgers, also a Republican and a former Speaker of the legislature, had been critical of the most recently passed law and also has Republican Governor Jim Pillen and some Republican lawmakers.
Well, I want to just clarify. Now, officially, the Nebraska legislature is nonpartisan, but most people know the party affiliation of the people. And that name of the Secretary of State, I've cut it from the decision, the EVNEN. It seems like a weird name, but that was the way it was in the article. So it may or may not be the Nebraska Secretary of State correct name, but we have a fabulous transcriptionist, and the transcriptionist will fix
it. I'm looking it up because I can't imagine that it's really EVN. Of course, I got all the other information other than the person's name. All right, we'll move along though. So I can't help but note that Evnen, God, is that really what it is? Evnen? Hilgers and Pillen make up the 3-member Board of Pardons. Since they are all in opposition, that means virtually no pardons will be granted.
That's pretty funny. That's quite an astute observation. The story states, based on the opinion, Secretary of State Evnen issued a statement late Wednesday afternoon saying he has begun directing county election officials to stop registering people convicted of felonies who have not been pardoned by the Nebraska Board of Pardons. Now remember, the 3 people that are in staunch opposition to it make up that board. Evnen said he does not intend to remove from the voter rolls those with felony convictions who were already registered to vote, but he plans to also to request the next pardon board's meeting in August that those with felony convictions who were registered to vote in the 2-year waiting period be allowed to stay on the rolls and vote. This kind of reminds me of the AG's opinion in Wisconsin dealing with the GPS tracking for life and about whether you had more than one conviction. And the AG interpreted it, his opinion said that it was it had to be, it could be two separate events within the same case. And then the Supreme Court of Wisconsin said, no, this reminds me of that situation completely.
Is the AG's opinion binding?
No, it's not binding, but it's persuasive because an elected official asked the Attorney General for an opinion. And, like last week when I sarcastically said, who the hell would you refer the delegation of the registration question of retroactivity to, the Department of Justice or to the Department of Agriculture? Well, this is who you would go to. You would go to your state's Attorney General and you would ask for an opinion if there's some ambiguity about whether it's constitutional, if you have some doubts. So, but based on the opinion, Secretary of State Evnen issued a statement late Wednesday afternoon. Oh, I've already done that, so go on.
AG Hilgers' latest opinion comes less than 4 months before a hotly contested presidential election in a state that allows its presidential electoral votes to be split. Nebraska's electoral votes tied to its 3 congressional districts go to whichever candidate wins the popular vote in that district. The state's Omaha-centered 2nd District has twice awarded its electoral vote to Democratic presidential candidates, once to Barack Obama in 2008 and again to Joe Biden in 2020. Do you think that this was politically motivated?
I have no way of knowing that. It's certainly a possibility. But I'm one of those, I like to hold out for evidence. When you start imputing sinister motivations without any evidence, it bothers me. But the Nebraska Voting Rights Restoration Coalition berated the opinion and Evnen's order to stop registering those convicted of felonies and said it's considering all options for immediate relief. Quote, "We cannot allow this decision to stand unchallenged," the group said in a statement. "We stand with voters who have served their time and deserve to participate fully in our democracy."
Evnen's office was asked to respond to criticism that the opinion and his order to stop registering people convicted of felonies seemed geared to disenfranchisement, a segment of voters only months ahead of a tight election. Evnen spokesperson Jackie Orada replied, "Secretary Evnen believes this opinion isn't geared to do anything other than follow the Nebraska Constitution." Well, Larry, what happens next then?
I don't see any recourse in litigation here. First of all, you got to overcome standing, and I guess the people that are not being allowed to register to vote would have that standing, but you got to have somebody with standing to file something. Where are you going to file? What are you going to style the action, the cause of action? Don't have a lot of time between now and election day to really do much in the court system that I'm aware of. So, other than recognizing that elections have consequences, folks in Nebraska, you have elected these 3 people to these statewide offices. If this is not what you want, when you sent your 49 senators to the unicameral, if you wanted felons who've served their time to be able to vote, then you need to communicate that clearly to these elected officials, to your Attorney General, to your Secretary of State, and to Governor Pillen. You need to make it clear that that is what you want, and that you will remember that when they're facing you for election and requesting their vote again, if this is what you wanted. Eitherwise, there's nothing that I can think of that's really effective that can be done in such a short amount of time.
Do either of you guys see a trend here? Do you see that?
Well, I've tried to bring this trend up before, Chance, and Larry always kind of squashes when I point something out.
Yeah, you got Mississippi, you got Nebraska. In Mississippi, Constitution can't fix it. In Nebraska, the legislature can't fix it. Okay, it's the Constitution. It's the legislature. What it is a trend to disenfranchise folks. And that's what I was talking about before. And it really is a disgraceful way of doing things. It's just ugly.
So,
let me ask you this though. Oh God, what was my thought? I wanted to point out that a particular patron who I speak to quite frequently, we text back and forth because he lives a million miles away. But he the last time, Larry, you brought up the elections have consequences episode, I got trashed by him a lot. He was really angry. He's like, "I effing know." He doesn't say that, but he said, I understand that elections have consequences. However, I live in a state where I can't vote. So what am I supposed to do? So he was angry for us pointing out and rubbing his nose in the fact that elections have consequences.
Well, I will continue to do that because a lot of the problems we face are because of poor choices we're making as voters. So if you don't like it, make different choices.
But in the case of a person that can't vote, what choices can he make?
He can make choices to go out and help candidates he supports that are in alignment with his views to win. He can knock on doors. He can make phone calls. He can place literature out for them. He can make cash donations to their campaign. He can do a whole lot of things.
Can I send him your way for him to beat down your door for this?
Sure.
You've met him. All right. Well, then we will move over to the one article, really, I guess. It says, this is from Courthouse News. This is a victory for those incarcerated. The story says Illinois inmates at the Will County Adult Detention Facility won a partial legal victory Monday with a federal judge in Chicago ruling that several of the jail's media and mail policies violate their civil rights. And what is the policy in dispute, Larry?
Oh, it's a good one. A ban on photographs or other materials that are determined to contain sexual or other inappropriate content at the discretion of the mailroom staff. Sexual or inappropriate content policies, number one. A ban on all material printed from the internet, media articles or pages from books or magazines, like maybe our NARSL newsletter. That's banned. Number three, a ban on any mail from a person or publisher or business whose return address is a P.O. box, kind of like us. Regardless of the contents and regardless of the identity of the sender, there's the P.O. box ban policy. Now, can you at least admit that's funny?
That's totally 100% not funny because like the FYP transcripts come from a P.O. box, if I'm not mistaken.
So under the challenge policy, plaintiffs are still permitted to access a broad range of publications, the judge added. But
they're still permitted to access them. Like probably wouldn't all, not all, don't take that literally all, but don't all businesses run from P.O. boxes?
Many of them do. Yep.
U.S. District Judge LaShonda Hunt, a Joe Biden appointee, found the jail placed unconstitutional barriers on inmates' access to certain forms of media and mail sent from P.O. boxes. However, the judge allowed the jail's ban on sexual and inappropriate material to stand. How did this case come about?
A Will County inmate first sued the jail, and it's located in the Chicago suburb of Joliet, on a civil rights claim in 2017 after he was denied mail because of the jail's media restrictions. These included, among other things, all those things I read, and the P.O. box. And in September 21, U.S. District Judge Andrea Wood, another liberal pointy-headed Obama appointee, certified a class of current and future Will jail county inmates. She gave this case class action status certification.
By that point, the inmates had expanded their claim to challenge unreasonable delays in the jail's mail processing and its ban on sexual content and other materials deemed inappropriate by mailroom staff. One inmate representing the class said the jail used the inappropriate rule to confiscate pictures of his wife. The inmate who originated the 2017 suit said in a separate filing he was unfairly denied a book on the history of tattoos based on the same rule. So what happened next?
Both the inmates and the jail moved for summary judgment, and Hunt issued her split decision Monday.
Wow. How did Judge Hunt decide the case then?
Well, she decided using the Turner test, and that was based on a 1987 Supreme Court case, Turner versus, whatever that is, safe. You tell me what that is. Anyway, to evaluate the
safely.
In Turner, the High Court upheld restrictions on correspondence between inmates at a Missouri jail, but also found inmates had a constitutional right to get married. The Supreme Court has explained that prison walls do not form a barrier separating prison inmates from protections to the Constitution. Judge Hunt wrote, "The First Amendment is no exception to that rule."
The First Amendment is no exception. The Turner test is a 4-factor standard meant to evaluate whether a prison regulation is justified and whether there are workable alternatives if a regulation negatively impacts prison staff or inmates. Applying the Turner test, Hunt concluded that the jail's ban on internet materials and other media content isn't justifiable. Hunt agreed that the jail has a security interest in banning certain content. It argued the bans were necessary to stop prisoners from fighting over personal beliefs, gang affiliations, and sexual preferences inferred from each other's media consumption. But those security concerns do not outweigh the inmates' rights, especially as Hunt found the jail could still review the media the prisoners have access to.
Yes, Judge Hunt stated, in sum, although the first Turner factor is satisfied, the court finds the media policy falls short of the remaining three factors and is unconstitutional. She was even more skeptical of Will County's ban on mail coming from P.O. boxes, further finding that as applied, the rule violates prisoners' right to receive literature. Under the Will County Adult Detention Facility's current mail policy, P.O. box mail is even denied when it comes from identifiable sources.
We said just a few sentences ago, that they're trying to prevent people from getting into fights over their personal beliefs. I'm trying to figure out, is that a way to say religious beliefs?
Yes, that would be
Which
that.
certainly happens, but like, how do you deny people to have from their religious freedoms?
Well, therein lies the problem, and that's what Judge Hunt has slapped this jail down for.
All right, and you've pontificated that summary judgment can be good. In fact, you conceded that last episode that summary judgment worked in Guy Hamilton Smith's case in favor in the Kentucky case. That's the case where the state required all PFRs to identify themselves by their name on certain social media websites. Did it work in this plaintiff's case? Did it work in favor of them?
It actually did. Judge Hunt wrote, without more evidence, defendants failed to meet the burden of proving a compelling government interest and their policy that their policy's least restrictive means of furthering such an interest. So as a result, the court grants summary judgment in favor of plaintiffs against defendants on the RLUIPA claim, otherwise known as Religious Land Use and Institutionalized Persons Act. Now, see, this is what I talk about summary judgment. See, everything's the inferences are resolved in favor of the non-moving party. So the jail did not get to have their assertions about the necessity of their rules. All the inferences were resolved in the plaintiff's favor because they were moving for summary judgment for a different list of reasons. But so the jail didn't have any evidence in the record of how vital their policy was, and that cut against them. If you ain't got no evidence in summary judgment, you're not going to win the case. And I keep telling these attorneys somehow they have trouble understanding it. When you file for summary judgment, you're conceding that there's no material facts in dispute, and then every inference is made in favor of the non-moving party.
Chance, Larry has made it very clear what his opinion of summary judgment is. What is your opinion of it?
Well, it is what it is, which is usually a disappointment. That's my personal belief.
Do you ever seek it?
I don't, because I don't do that kind of stuff. I do criminal law, so I don't really engage in that. But every time I read about it, I see it. Generally, it means disappointment. Well, I don't think Larry would disagree.
I certainly don't. I love summary judgment when there clearly aren't any facts that can be disputed. But lawyers use summary judgment not in that limited situation. They use summary judgment because they want to move the case to a quicker resolution, and they don't want to offend a federal judge that's looking at them saying, "Counselor, can we work this out? Am I going to have to sit through a trial? Don't tell me that." I mean, the federal judges are very intimidating, can be very intimidating. And they don't want to disappoint the federal judge, so they say, "Oh, yes, Your Honor, we can have some stipulated facts." You might get the state to stipulate to some facts, but you're not going to get the state to stipulate to the facts that you really need them to stipulate to. They're just not going to do that. They're not going to agree that the registry is punitive. They're not going to agree to all the things that we need. So therefore, you're going to have to put on a trial. And I see case after case after case where if you read it, it says there was insufficient facts in the record. The record didn't support. We see that right here. This judge says that the record didn't support the summary judgment request by the defendants. So, I mean, hello? I mean, I don't understand what's hard to see. But anyway, we got to get this California corner in here before we run out of time.
We do, but then I just added something at the end that we have to do. So after we do California corner, I got one other thing to add.
All right.
Chance, take it away, sir.
Okay.
California Corner.
Okay, so in the past we've spoken about post-conviction relief, the mechanisms, how to go about doing it in California. This is how you can help yourself in setting that up, setting the stage for post-conviction relief. Now, the goal of post-conviction relief is generally reintegration. And what I mean by that, reintegration is generally understood as a multidimensional process enabling individuals to reestablish the economic, social, and psychosocial relationships needed to maintain life, livelihood, and dignity and achieve inclusion in civic life, believe it or not, even after, say, Mississippi and Nebraska. Now, the ultimate issue here is how do I set the stage for my reintegration back into the community? As I see it, there are 4 basic steps. Now let's go to number 1. Number 1 is take responsibility for your conduct. Be accountable for the conduct that led to your conviction. When discussing it with others, be transparent and sincere. Own it. As the late, great Jimmy Buffett might say, some people claim there's a woman to blame, but I know it's my own damn fault. Own it like that. Taking responsibility may happen instantly or maybe a process, but one thing's for sure. You can't achieve post-conviction success without it.
Well, Chance, why not? Why can't you do that? Why can't you achieve post-conviction success without it?
Well, not just because it's the first step in my analysis here, but because a person who refuses to take responsibility is seen as being in denial, and as such, a threat to the community's safety. So there's no moving past this point.
What if it's not denial, but rather an actual claim of actual innocence?
Now, that's a different story for another time. For our purposes today, we are presuming guilt, and with that in mind, let's move to step 2. Be remorseful. Remorse is an emotional expression of personal regret felt by a person after they have committed an act which they deem to be shameful, hurtful, or violent. It is closely allied to guilt and self-directed resentment. Remorse is deep regret or guilt for a wrong committed.
What is the lack of remorse, and why is taking responsibility so important?
Now, it's kind of counterintuitive, but it is a lack of remorse is a complete lack of conscience, lack of empathy, guilt, or shame. A psychological evaluator views these traits as an antisocial personality disorder, sometimes called sociopathy, which is a mental health condition in which a person consistently shows no regard for right and wrong and ignores the rights and feelings of others. The importance here is once you take responsibility for your conduct and can emotionally express personal regret for it, you're able to move on to more important aspects of the process, such as step 3, developing insight. And let's move on to developing insight. Insight, for our purposes, is being able to see or understand something clearly, such as what caused you to act out and commit a crime.
Is this just as important as taking responsibility and showing remorse?
Yeah, actually, Larry, it's more important. Being accountable for what you did and deeply regretting it does not reduce the risk of reoffense. However, understanding why you did it does. In other words, you can't prevent a reoccurrence if you don't know why it occurred in the first place. And let's take another song here by Steely Dan. Steely Dan says it best. You go back, Jack, do it again. We'll turn round and round. You go back, Jack, do it again.
Shouldn't this be kind of a fairly easy task?
Well, we're good at helping professionals establish psychological or physiological factors such as lifestyle, addictions, impulses. We're good at recognizing triggering events like anxiety and stress, but we're very poor at discovering underlying causes of our conduct because they are so painful and we want to forget about them. Who wants to tell a complete stranger, like a psychologist or a probation officer or an evaluator, that their father beat them, that their mother abandoned them, and that as a result of that, they're angry, insecure, and engage in inappropriate behavior and toxic relationships because they are constantly seeking acceptance and attention by any means necessary. I mean, but here's the thing. If you can't go there, you can't get to the most salient part of the process, which is step 4, creating a post-conviction prevention plan. And let's move on to that. What I mean by prevention in this context is the action of stopping something from happening or arising again. A post-conviction prevention plan is based on keen insight. For example, I understand the underlying cause of my prior conduct, and I was seriously abused. I was a latchkey kid who chose to suppress my feelings of isolation, abandonment, and anger. Now, I'm not talking about me. I'm saying in general, that's a keen example of insight. Okay? Following this keen insight, you might say, I know what triggers it, because you found that out, stress and anxiety. I know what aggravates it, drugs and alcohol. And I know what to do what happens. Rather than succumb to the triggers and aggravate the situation, I now seek guidance and help from my family, friends, pastor, counselor, therapist, or doctor. If you can achieve these 4 basic steps, you have set the stage for your reintegration back into the community, and this will assist professionals, including your attorney, in helping you get there. Gentlemen, your thoughts?
I think
Go ahead, Larry.
I think that's a great list of things for your post-conviction. You just have too many liberal ways in California for people to get relief after being convicted. We need to shut down some of that stuff over there.
Yeah, there's 1,000 ways to thrive here.
Yeah, well, we need to stop that.
Hey, Chance, in what you've outlined, is there, like, I am a non-religious person and do not attend any sort of religious institution that would then vouch for my character, so to speak. And I find that to be discriminatory on its own, probably for a different conversation. But how does somebody going through these steps, does it help them in having you represent them in building like the packet for them to get relief, that they're doing the right things as a citizen, etc.?
Yeah, I mean, this is the basic foundational building blocks for that. And yes, you don't have to necessarily be affiliated with a religious group. There are so many, and there are so many different ways to develop this and document this process, which I think you're asking me. So yeah, there's many ways. People hire me to help them do that. And but we start with these basic building blocks. The reason I bring it up now is because every time I get a call or someone asks me about this, or I start off on a path with someone, say that I'm consulting with, they none of this stuff, is very clear to them, and it takes time to really explain it to them. And I think it's beneficial to know these at least these 4 steps.
I gotcha. I'm thinking of where all the different, like, it just, I was alone for almost entirely. So it's like, to me, it was beneficial that there was nothing to report on, that obviously there weren't any tickets of any kind, no speeding or anything like that. It's like, hey, I'm going before the judge, and I hope there's nothing to tell them, because then that would be good.
It's good, Andy, but it's expected. You're expected to do that.
Of course.
Everybody's expected to do that. What I'm talking about is beyond that expectation, thinking outside the box, continuous work on issues that show that you are committed to the idea of rehabilitation and reintegration. That is where the rubber meets the road.
Very good. I don't have anything further there. Do you, Larry?
I do not. Thank you, Chance, for that.
You're welcome.
Hey, well, I'm going to spring something on you two. We do have just a handful of minutes left. And I was on Narsal Connections today, and somebody in North Carolina posted, if you can see, I posted the pictures in chat, and I'll get the screen to show up here, that a person goes to Food Lion, and there's a sign posted that says, PFRs are restricted in this area. They can't be on the property or in the grocery store.
Well, it doesn't actually say that in what I'm reading here. It says authority of the Eastern Band of Cherokee Indians Code of Ordinances, criminal law. It says in restricted areas. It doesn't define what is a restricted area. We'd have to see what that section 14-50-.26, what areas are restricted. Is the entire store restricted?
Well, then he posted by someone later. He said, not allowed in the store or the parking lot, the manager said.
Okay. Well, but the manager doesn't do the enforcement. If that's in Indian territory, the Indian nation would do that. But what does the ordinance say? And then beyond that, how would they identify you as a sex offender? Are you emitting some kind of radioactive isotope that would pick it up on a Geiger counter? How would they know?
Yeah, that posting right there is just kind of bizarre because, I mean, you might want, if it applied to anything it's posted on, it would say registered sex offenders prohibited, and then it would have a citing to a statute. How do you make out where the restricted areas are? Well, as Larry says.
Well, it does say down at the bottom of the yellow sign, section 14-50.26.
Yeah, but it should just stop at prohibited in restricted areas. That's what throws the whole thing off.
So, but yeah,
how would they know you're there? Is Food Lion running like casino grade facial recognition stuff to compare you to the PFR list in North Carolina to find you, and then they're going to just come up to you and tap on you and say, "Sorry, kick rocks. We don't want your kind here"?
Yeah, I mean, I'm going to dig into this ordinance a little bit for hopefully the next episode and see if I can figure it out. But my first reaction is I wouldn't be overly alarmed about it, but it may be something to it.
He said he did contact corporate and they didn't know anything about it. They said the manager said they did.
So
that's weird.
I thought North Carolina wasn't one of the worst places to be, but that's pretty bad.
Well, this is not real. This is not citing to North Carolina law. It's citing to a Cherokee Indian law.
I get that. It's still in North Carolina, though. But I get what you're saying. It's in a territory.
They're an independent nation. They're not governed by North Carolina law.
I gotcha. Well, anything else, gentlemen?
No, that's about it.
Larry, anything?
That's it. I appreciate being back this week. I'll see you in about a month when we record again.
Whoa. Okay. No, I wasn't thinking it was going to be that long.
I thought we were going to take off August.
We will be taking off at the end of August. I will be going to the beach.
So
I do want to say that I mentioned earlier, but Mr. M and John they have impeccable taste in podcasts by increasing their support for the program, and we can't thank them enough. Very much appreciated. Head over to registrymatters.co to find the show notes. And then you can leave voicemail. I'm probably going to have to just turn off the phone because nobody even calls. Somebody just call and make sure the thing still works. 747-227-4477. Leave email at registrymatterscast@gmail.com. Or you can email crackpot at registrymatters, and that'll get to Larry. Just kidding. And then, of course, support over at patreon.com/registrymatters. And I don't have anything else. And I hope everybody has a great weekend and you stay out of trouble. And we will see you in a week or so. Take care.
Good night.
Good night.
You've been listening to FYP.